So Vinay Sharma's case was relating to the Nirbhaya gang rape case, okay, in Delhi. This now, what happened was this was for one of the convicts who was convicted for the offense and sentenced to death by the trial court. And this was confirmed by High Court, okay, and by Supreme Court later. So what happens if there's a death sentence? You have an option to apply to the president for mercy, right? So this was a presidential pardon was applied for, denied, and then there was a review application. The presidential pardon was denied, and a writ petition was filed. Like basically, the person went to the Supreme Court to challenge the pardon being denied. So it is about review of presidential pardon before the Supreme Court. Okay, this is the link. I'm going to show you this. So there are 5 steps I'm going to talk about. Okay, from the cause title, you are going to read the name of the case, the parties' names, right? You need that to cite the jurisdiction of the court name, and the name of the judge. Okay, so can you see that the first window, if you open the link, is going to tell you that, right? And what's the jurisdiction here? So name of case, Vinay Sharma versus Union of India, Justice Bhanumati writing it. It's not criminal appeal, it's written on the judgment, right? Supreme Court has a different criminal appellate jurisdiction, but this is writ petition criminal. It's written, third line, right? Those are the things you have to catch. Okay, criminal writ, not appellate, guys, not appellate. You can generally say like appellate, this would not work, appellate won't work. Criminal appellate jurisdiction is different. This is writ petition criminal. Look, it's written here. I don't have to apply my mind. It's written here. You can just use this, right? Okay. Now look at this. Step 2. Now I don't advise you to start reading from scratch. Okay. I'm telling you how to go about reading it. And this is a counterintuitive approach. Counterintuitive means people don't use this. Okay. But it gives you results very fast. Okay. So now you know Vinay Sharma is what? Petitioner. Union of India is respondent. Now, important thing, who won? Read the last paragraph to know the decision and other important points, because you may forget everything in the case, but you will remember, oh, this was the case, this party won, and even that counts if you are having a bad day, right? So number 65 of 2020 was the registry filing number at the Supreme Court. Okay, that number is not necessary to remember. Who won, appellant or respondent? Read this and then you tell me who won. Confirm which judge issued the opinion, how many judges signed it, look for any dissenting judgments. Exactly. So the petitioner failed, right? Union of India won. The pardon was not successfully challenged. Okay. Now you saw the Justice Bhanumati wrote for 3 judges, Ashok Bhushan and also for Justice Bopanna. Okay. So 3-judge bench. Okay. Now with this, you're making progress without reading much of the case. And we are going to use this strategy. Now, step 3, you only read first couple of paragraphs to understand how the case reached the Supreme Court and the High Court. This is way more important than the detailed facts. Trust me, the reason, if you read a trial court judgment, it's often simpler than reading High Court, Supreme Court judgment. And we always read High Court, Supreme Court in class because that is what is important. It has a precedent value, right? So we are reading all these judgments. Now, what happens is that by the time the case reaches the High Court or Supreme Court, there is so much story about it, right? Now, I can't write that story in the judiciary exam. And this is a very important point to know. I can't write the whole story, whole Ramayana, Mahabharata that I know. I can't write an epic in the judiciary exam. I have to write only focused points. So the best way to do that is I will read only little. The most important stuff I will find and I will read and I will learn that, right? So I'm going to tell you how to go about that. The petitioner is a death row convict. This is para 2. Okay, is a death row convict in Nirbhaya's case relating to the gang rape of the victim in the moving bus in Delhi on the night of 16th or 17th December 2012. Trial court by its judgment date convicted the petitioner and other co-accused, okay, and the sections under which they were convicted. The trial court imposed death sentence on the petitioner. The High Court confirmed the conviction and co-accused. Okay, confirm the conviction of the petitioner and co-accused. Under CRPC, the death sentence is to be confirmed by the High Court, right? Yamak, yes, this can apply in litigation also. Okay, this will help you get a grip of cases very fast. Then what happened? So High Court confirmed the conviction. and the sentence imposed. For awarding death sentence, the trial and high court have recorded reasoning. Okay, and then it says here, after referring to various judgments, and here the line here, challenge in this writ petition is the rejection of mercy petition by the President of India under Article 72 of the Constitution. So now you know this can be asked under constitutional law or maybe under criminal law, right? Two possibilities, constitutional law or criminal law. So this is the one on point. Challenge in this writ petition is the rejection of mercy petition by President of India. See, when you are reading newspapers, you are going to coaching, okay, you will come to know which cases are there. Or you're doing self-study, you will find out, right? That's a separate method. But when you find a case, I can give you a list of 2000 cases. How will you read it? Question is not finding the case. You're going to read more cases than what is going to be asked. Nobody knows which case is going to be asked, right? So you will read a few more cases than what's going to be asked. Maybe you'll read 100 cases or 1000 cases and you will have question on 20 cases. But you will still read that, right? To succeed in the competition. That's why I am saying that once you have the list, like we give our students list of cases, then you need the reading and study technique, right? Studying is your job. Your job is not to reinvent the wheel. Okay, so challenge in this writ petition is rejection of mercy petition by President. Clear. Now step 4, read. But what will you read? You will read in a certain way. And I call this method Oprah. I have taken like Oprah Winfrey. It's a talk show in the US. So I just thought I'll make a mnemonic from it. So Oprah is the mnemonic. Okay. Read the sentences of every para, but only the first sentence. And you only have to mark it. Okay. So you just have to mark it. So read the first sentence of every para to know whether it is the court's opinion. Because if it's opinion, you will use it. If they are referring to precedent, you will not use it. You will go back to the precedent if you need to mug more cases or you want to learn more cases. Okay. If it's an argument of the respondent or appellant, you may use it for your understanding, may not use it in detail for answer. But court's opinion, where there is a new ratio that's coming, new judge, new reasons for the decision are being coming, there you will say, okay, I need to read this, right? So you do Oprah and you use mostly the O of the Oprah, okay? And you use the precedent or argument of respondent or appellant for just your understanding at best, and only that much as is needed for the issue. Okay. Lines. So curative petition was filed, but this case was not about the curative petition. So that part of the facts we ignore here. This case won't be asked for curative petition. Now I'll show you what the lines from the court's opinion look like. Okay. Usually it will be like, in our opinion, in our view. Okay. We cannot agree with the argument of counsel. By perusal of file produced before us, it is seen that, so they use like sentences like that. In light of the above principles, let us consider, right? Para 14, in the light of above principles, let us consider the present writ petition and the grounds urged. So now you understand here that the court is summarizing, right? And they are going to give their opinion. So the petitioner has primarily raised the following grounds. So here you're getting a summary also. That means I can ignore the arguments of the petitioner. Why? Because court is summarizing it. And I also know that after 2-3 paragraphs, I will get the court's opinion on the point. So we got it. Insofar as the contention by the learned counsel that the file, this was about a file not being shared with the precedent for the mercy petition. Okay. So the court says, we are of the opinion that such a course would not be appropriate. Okay. Then similar line in another paragraph, para 24, they said, by perusal of the file produced before us, it is seen that, this is their opinion, there is no merit in the contention that the medical report of the petitioner has not been placed before the president. So from the top and the bottom line, I understand that the court is giving me opinion and this is what it is deciding, right? Even if it is more than 200 pages, you can use this method to break down what is important. Your understanding, because you'll find out which are the judges, who is the leading judgment, who wrote the judgment of the majority, and then you'll break it down like that, right? This is not skimming method. Okay, this is not skimming method. This is like a custom method that we have prepared. It works like a charm. Why? I'll tell you. You just follow this, all the 5 steps with me. You will realize how it saves you time. Okay, now I am showing you. So here I showed you for opinion, right? Oprah was the acronym. So opinion looks like this. Precedent looks like this. As held by the Constitution Bench in Maru Ram versus Union of India and Vikas Chatterjee, the court will keep in mind that where the power is vested in a very high authority, it must be presumed that they would act carefully. So if you are reading this paragraph, even if it doesn't necessarily connect with the case, you understand that these two cases, the court has said that a higher authority, it will be presumed that it is acting objectively and carefully where the decision has been placed before them, right? Now, this adds to your knowledge of case law and principle. Now, look at, so how will you use precedent? If you are doing case search, looking at other similar cases, okay, those people who are interested in litigation, then you will backtrace this, okay? One more thing you can do. Sometimes you are reading about constitutional law in a textbook. That textbook doesn't mention this case because this is a recent case, but you will find that case here if it is relevant to the principle. So all your knowledge will get refreshed, right? So this is the case law part, okay? Not the most important, okay? We are finding out parts you can mark and ignore also. Most of the work is about ignoring, okay? And I'm going to show you that. Example of an argument. So beginning line only of the paragraph will tell you, learned counsel for the petitioner then urged. This is an argument. I can remove it if I want, right? I can ignore it. I'll mark it and write argument for petitioner. So P, Oprah, I will write respondent and appellant was there. So I'll write A here, okay, and I'll ignore. Solitary confinement. Learned counsel for the petitioner argued that, again, ignore. Petition. This is an argument, not the law laid down by the court. So you can mark it. O is for opinion, P is for precedent, R is for respondent, A is for appellant or petitioner you can write for.